Did you also have an opportunity to review all the photographs taken under the same DR number, both at autopsy, the various crime scenes, the crime lab, and everywhere else?
Yes, I have.
Were you all provided trial transcripts and other transcripts associated with the prosecution of Mr. Valerio in 1988?
Yes, I was.
And did you also receive information as to a prior robbery committed by Mr. Valerio in 1983 and a battery with a deadly committed by Mr. Valerio in 1986?
Yes, I'm aware of both of those.
And finally, were you also, did you find within the electronic file provided to you photographs of Karen Blackwell and Summer Blackwell and one of Roger Blackwell in real life?
Yes.
Did you review all those items?
Yes, I did.
And do you feel comfortable sort of describing to us in a summary fashion the nature of the case, the investigation, and the arrest of Mr. Valerio?
Yes, I can do that.
Your Honor, may we have a sidebar?
Okay.
And welcome back to the Law News Network. I'm your host, Caroline Polisi, where we're catching you up to speed on the John Valerio trial. It's a case out of New Mexico. It's a retrial of the penalty portion of this man's murder case. He remains guilty for the murder of Karen Sue Blackwell. Join with me today. I'm so happy to have Deborah Blum, LawNewz's very own trial analyst. Thank you for being here, Deborah.
Thank you for having me.
Yeah, I want to really get into this case because, you know, we're getting up to speed for the 4 p.m. We're going live in the courtroom there, and it's expected to really end soon. So I want to talk to you a little bit about, first, we just came from a clip of a former Metro officer and a retired detective, and they're getting on the stand 31 years after they interrogated this case. What is going on?
Well, in a case like this, there's no time frame. So usually in a murder, there's no statute of limitations. Clearly here, this is a special circumstance. The Court of Appeals said you have to re-examine the death penalty portion of this matter. But, you know, people forget things in 30 plus years. So that's going to be a difficulty for the prosecution here.
Absolutely. Can you imagine? I mean, talk about stale evidence, right? I think we're seeing some issues with sort of recollection issues on the stand. Anyway, I want to talk about, so the key issue that the Ninth Circuit said in this case was that one of the jury instructions given was actually unconstitutional. So I was talking to our previous guest about, we both know as defense attorneys that, you know, you don't just write up a pattern jury instruction and send it to the judge. You work really hard on those jury instructions and you do research into sort of the case law as to anything that you can get, because that's really an important part of what goes to the jury. Can you talk a little bit about what goes into deciding what you're going to argue to the judge should be said to the jury?
Absolutely. You know, I think that the judges on my cases usually regret having me as the person that's before them, because I basically torture it. Like, I go overboard because I want to be so prepared and I want to zealously advocate for my client and protect his or her best interests. So you go into it, there are standard jury charges, such as the defendant doesn't have to testify. That's a standard one. You know, in most criminal cases, the defendant does not have a burden, so the judge will instruct the jurors about that, as you know, or if the defendant raises an affirmative defense, there'll be a jury instruction about that. In this case, if I was the prosecution, I certainly would want to make a charge that explains, you know, we should not be penalized for the 30 plus years that have passed here. And they can do that by looking at their state's pattern jury instructions and tailoring it to the specifics of their case. So if you have the standard jury instructions, usually the defense and the prosecution don't fight over those, but sometimes as a defense attorney, you want to expand upon a definition. So if it's an intent-based crime, you'd want to have a greater definition and explanation of that by the judge. So a lot, as you said, a lot goes into these jury instructions, and here there's a very unique circumstance.
Right. Very unique circumstance, I will say. So the issue that we're litigating here are, of course, whether or not there are enough aggravating circumstances. Nevada is what they call a weighing state, meaning that the jury is going to weigh aggravating versus mitigating factors here. What in your mind are the aggravating factors?
Well, Judge Pamela Reimer, who wrote in the dissenting opinion, said that this man had stabbed the victim 45 times in clusters of 8 on the head and neck and breasts and elsewhere. And that was murder with torture or serious physical abuse. So to me, that's an aggravating factor. This isn't a case. I recently handled a manslaughter case where the defendant was accused of stabbing an individual 1 time. Now, in a case like that, where there are so many reasons why he should not receive the death penalty if it were a death penalty state, there would be a lot of mitigating factors. Aggravating factors could be prior propensity towards violence, I imagine. So if this man has a long history of doing this, the way that the person died, which here was an extremely brutal death, any death by murder is a terrible thing. But there are sometimes circumstances which mitigate it, and it's very possible here that he will still receive the death penalty.
Absolutely. Well, talking about mitigating circumstances, we've been reviewing this morning some testimony that the defense is putting forward, trying to really humanize this defendant. So we've heard from his stepmother, his father, saying that the divorce that occurred when the defendant was young really had an impact on his life. What do you do as a defense attorney? Not obviously you don't do death penalty cases, but say in a sentencing when you're putting forth mitigating factors, what's really the goal of the defense attorney in that role?
Well, the goal is to get your client a better deal. I'm actually putting together a mitigating factors letter right now, and it takes an incredible amount of time. You get letters of support, so the district attorney or the federal prosecutor or the court can see your client beyond just as a criminal. Many people that commit acts of crime have mental disease, and we send those people to prison where the staff there does not provide them with the medication, or if an officer doesn't feel like taking that person for treatment, they're simply not going to get it. So a lot of times alternatives to incarceration can serve the greater community, and you rehabilitate somebody by having them, let's say it's a person that didn't go to college and didn't have certain opportunities that many of us Americans have. You want to get them access to those opportunities so they can succeed.
Absolutely. Now the jury here is deciding between 3 different possibilities. The first is life with the possibility of parole. However, an interesting twist in this case, again, it's 31 years later. He's already served that many years. He would therefore be eligible for parole if that's what the jury decides right away. So we've seen some arguments on the stand. We've heard from former prison wardens that oversaw this defendant while he was in jail. Can you speak a little bit about how you navigate with, in my case, it's the Bureau of Prisons when your defendant is in custody. And we were talking a little bit earlier about sort of the lower due process sort of rights of defendants once they're in custody.
Well, as you know, the Bureau of Prisons is not always the easiest to get in touch with. Right. And as you know, we use fax, which many people find surprising that in this day and age people still use fax so often. But it's very difficult. I have noticed a difference between state facilities where my clients are. Some are much easier to communicate with. I had a case in Westchester County. I actually received a phone call from the warden of the prison in response to a question that I had. And I was shocked that he took the time to give me a call. And I thought that that was tremendous, and that speaks volumes to that facility. Clearly, at that facility, their goal is to actually rehabilitate. But in other facilities, if you send in a request, like I'd like to bring in my laptop so my client can review the discovery materials, you don't get an answer. And you've been inside the federal prison, and it's very similar to a state prison. There are very few facilities, and in this day and age, everything is on computer, and the inmates don't have access to a library that has a computer that runs. So they're unable to assist in their own defense. So it can be very frustrating for both the incarcerated individual and also for the defense attorney who's trying to help them.
Absolutely. And as a previous guest was saying, the benefit of the doubt always goes to the Bureau of Prisons because you have a guilty defendant already. And a lot of times it's difficult to communicate to your client client that you're not in the legal system, the criminal justice system per se. You're within this sort of murky world where you kind of have to negotiate with the wardens and whatnot. So it is difficult. I want to talk about the idea of an aggravating circumstance, because I think there's some confusion in the lawyers were arguing yesterday about whether or not the aggravation or the aggravating factor has to go above and beyond the murder itself. So you noted quite logically that this murder included stab wounds, 44 stab wounds, which sounds horrible, sounds horrific. But the question is whether or not the aggravation needs to go beyond the physical act of those stab wounds. We're going to go into some case law about that. So we're reviewing from the bench. I want to go to JV5 now. This is a discussion of what aggravating means, and then we'll talk with Deborah about it when we get back.
All right. So hearsay apparently seems to be admissible as to the aggravating, but it does seem, looking at the Thomas case, that you have three proper purposes for which a state may introduce evidence at a capital hearing. One is to prove an enumerated aggravator. Two, to rebut specific mitigating evidence. Or to aid the jury in determining the appropriate sentence after any enumerating aggravating factors have been weighed against any mitigating circumstances. Evidence submitted for the third purpose is what we mean by other matter evidence, and is not admissible for use to the jury in determining the existence of an aggravating circumstance or weighing against the mitigating circumstance. And it seems at this point his testimony is going to be going into both.
And that's why there's
circumstance.
Mutilation, depravity of mind, but the instruction is actually a set of instructions in the package I sent you. It's the evidence instruction. What they tell the jury is, in order to consider other matter evidence, you must first establish the nature of the aggravators, and then the aggravators outweigh the mitigators. Now, I would suggest to the court that the other matter evidence normally is not evidence associated directly with the crime, although at times it can. In Thomas, it was directly related to the guilt phase. They couldn't get a witness on in guilt, so they put his hearsay statement in penalty. But I'm going to suggest to the court that they are sentencing this defendant for the crime that he committed, and I don't think this is other matter evidence, nor is it necessarily all aggravator evidence. Some of it obviously is aggravator evidence, and it's certainly not mitigation. This is sort of a unique experience because of the penalty hearing, as the jury has no idea what happened in the underlying case in this particular situation, and those aren't actually captured in those instructions. Other matter evidence is normally other character evidence of the defendant. This is what I would call under 175.552 as any other thing relevant to the determination of the sentence, which that's what I would say this testimony is I don't actually think it's any of those three, because it's something that normally you don't need to do in the penalty phase.
Well, I mean, it seems to me that it comes in as other matters evidence because it's relevant as to the jury's determination of the appropriate sentence after the aggravating circumstances have been weighed against mitigating. Let me just say, what was the instruction again? You have that?
You have that, Tom?
I do, and I would note, Judge, if you read Summers, it's the last two paragraphs of Summers, they say the dissent and the concurrence say the Supreme Court someday may find that the aggravating circumstances confrontation clause may apply. However, even assuming that's true, we could instruct this way. They are not in any way suggesting that that instruction is an appropriate instruction in this case. If you want to read the evidence instruction, that would be one thing, but the instruction that they reference in Summers is not one that they're saying would ever be given until the Nevada or until the U.S. Supreme Court decides the confrontation applies to the aggravators of the eligibility, what they call the eligibility phase. You got to read the last two paragraphs of Summers together in the majority opinion to understand what they're saying.
The last two paragraphs of the concurring opinion?
No, last two paragraphs of the majority opinion where they say the dissent and the concurrence say this is going to happen in the future, and thus unbifurcated penalty hearing is unconstitutional. Then they go on to say, even if that happens, it won't be unconstitutional because we can give this limiting instruction. But certainly under the state of the law as it is now, that instruction is not appropriate.
Let me see the instruction again.
This, and all this is the stock instruction on evidence admitted for one purpose and not another, where we try to modify it, and it has to be modified for the specific thing. Good. I guess I should have cited.
So you're introducing at least some of this evidence in reference to the aggravating factor of depravity of mind, that being either mitigation if I allow physical abuse beyond killing.
Yeah, as well as he may have addressed the two priors too, which are also related to the two aggravators.
Can I just interject something that
I'm sorry, he's going to introduce what? I didn't.
He may address the two priors too, the 84 and 86 priors.
Okay. All right, go ahead.
There was a case in the last Supreme Court case called Tavares, Tavares v. State, and I can't read where the site is that we have it. Yeah, okay. 117 Nevada 725 2001. All that basically says is that upon proper request, well, actually it says upon proper request, a limiting instruction must be given, and then it says with uncharged conduct evidence, it's the obligation of the state to provide the limiting instruction. We're asking for the limiting instruction now. Obviously, when we settle instruction, we'll ask for the appropriate instruction. This is where we're questioning the limiting instruction. And I'm getting, well, you didn't want to talk about the depravity of mind now, you wanted to wait?
Yeah.
Okay. All right.
Welcome back to Law News. I'm Caroline Polisi, and I'm here with Deborah Blum, LawNewz's trial analyst here. So, Deborah, we just heard this sort of argument back and forth outside of the presence of the jury regarding aggravating factors and sort of what constitute the key issue here was the depravity of mind instruction given in the first trial. Mm-hmm. And one of these issues raised by the Ninth Circuit in its decision to retry the sentencing portion of this case was the United States Supreme Court decision in Godfrey, which made it clear that depravity of mind instruction is unconstitutionally vague. Now, let's talk about what that means in layman's terms. So I think, as a starting point, the idea is that what the Supreme Court said, you need to have some distinction, right? You need to have a practical way of saying these cases are death penalty eligible and these are not, and saying merely depravity of mind, what does that do to a jury? It could mean anything. What's your take on that?
Well, I think this is actually a very interesting issue. In some of the cases that I'm sure you talked about and I've talked about here in Florida, there was an issue with the death penalty there as well. If you look at the law, a lot of times, even as a defense attorney with a lot of experience, it's difficult to decipher what the definition of something is, what constitutes serious physical injury, what is a weapon, what is this, what is intent. Obviously some of those things are basic, but when you get into detail, it could be extremely confusing. And it's the same thing I imagine that happened here, is that there's a arbitrary definition that probably just didn't make a lot of sense, and it was not defined enough. So you're taking people's lives when the jurors who are determining this are most likely extremely confused and not exactly sure what law they're applying.
That's exactly right. Let's talk about picking a jury in a death penalty case. I mean, I have to imagine that would be difficult. Can you speak a little bit about, I don't know if you use jury consultants in your practice or what you do during the voir dire process to sort of get jurors that you feel will be favorable to your case?
Well, if anybody wants to hire me as a jury consultant, they're certainly welcome to, because I have not used a jury consultant and I've had a very good track record with my trials. A lot of it is really feeling. That's one thing. If somebody is giving you bad vibes, then you know that you don't want them. If somebody is too eager to be there, you also do not want them. Then, depending on the type of crime, there could be a certain group of people that you would want. In some cases, you want a woman. In some cases, you want a man. In my experience, jurors typically do the right thing. So as long as you're able to eliminate people who are going to be extremely overbearing. So let's say you have a trial where people are leaning towards a not guilty. All it would take would be one juror who's going to persuade everyone else to have a guilty verdict. And that can happen, and then you're left as a defense attorney feeling terrible that you did not get rid of that juror. So there's a lot of consideration. It depends on the type of case. In a death penalty matter, you certainly need someone that has the stomach to be there.
Absolutely. To really, as we know, jurors are supposed to make a, quote, dispassionate analysis of the fact, but it's incredibly difficult to do so when you have such a horrible and really atrocious crime. So I agree with you there. It's a difficult thing. I'm not one who believes in jury consultants. I think it's not necessarily based in science, but others disagree. Nonetheless, I want to talk a little bit about sort of the death penalty in general and your feelings being a criminal defense attorney and dealing with these types of issues. Where do you see in the criminal justice system in general the implementation of the death penalty going?
Well, this brings up an very interesting question. In Johar Tsarnaev's matter, the Boston Marathon bomber, he received the death penalty. And I personally think that it probably would have been greater punishment for him to sit in jail. You and I go inside the jail. I'm sure you've visited your clients who are in the SHU in federal prison, and it's really awful to be there, to be isolated. You maybe don't get to go outside. You are paying the price for taking somebody's life, especially when you've done it in such a heinous and unforgivable manner. There is no way that that person is going to have an enjoyable moment for the rest of their life. And then their family members are also suffering because their family members now have this burden where their loved one is sitting in jail and they're trying to communicate with them, and it almost becomes their life. So in some ways, having somebody serve a life sentence without the possibility of parole, in my opinion, is just as much punishment as letting somebody get out of it, because being in prison could be a really awful experience.
Also much cheaper just to implement a life in prison sentence as opposed to implementing the death penalty. We see here in this retrial of a matter 31 years later, it seems to me this is kind of a waste of judicial resources, prosecutorial resources, and time for the court that could perhaps be better spent. Just my opinion, though. I want to go back to a clip here. We're going to see James Vaccaro. He's the retired detective. It's JV10, and we're going to hear from him about a vehicle that he stopped.
Do the cops follow this truck?
They do. They created surveillance following the vehicle for a long period of time. One of the detectives associated with the case wanted to pull alongside of the vehicle so that he could visually look clearly at the individual to determine if it was John Valerio. At that time, most of us were in possession of a photograph of Mr. Valerio. And so we were trying to ascertain before we stopped the vehicle if that was in fact him.
Was there some confusion, but did he look differently than Detective Hatchett described him?
Yes. Throughout that early part of the investigation, right after the shooting, he was described as possibly a Hispanic male with a full beard. And the individual in the car with Billy Childers, or in the truck rather, did not have a beard but had a mustache. But one of the detectives did announce over the radio to everyone that it was approaching the area of the Naples residence. They were coming back to that area, and that the individual in the vehicle was in fact John Valerio.
Does the vehicle ever wind up going back to Naples, or does it go somewhere close?
It gets very close. It ends up right south of Naples and Paradise at what was then a Macayo's restaurant. It's gone now, but there's a parking lot. There's a business right at that intersection, and then just to the south is an open desert lot now, but there was a Macayo's restaurant. And it was at that location that it was collectively decided by the members of the surveillance team to take the vehicle down or do a felony car stop on the occupants of the vehicle in the parking lot of Macayo's.
And eventually the occupants removed.
Right, SWAT officers at gunpoint removed those occupants to the ground outside of the pickup truck.
And was Mr. Childers as well as Mr. Valerio identified as the two occupants of that
Yes, they
vehicle?
were.
Now let me talk, first of all, you wind up taking custody of Mr. Valerio at that point, is that correct?
Yes.
Let me talk about Mr. Childers. Does he wind up providing an interview to detectives investigating the case?
Yes.
And what does he explain about how it is Mr. Valerio wound up in his truck this day?
In brief, Mr. Childers' version is that his friend John Valerio came to his residence with a story that he had been shot at in his vehicle. He said that he needed to take a shower and get some fresh clothing, and that he asked for Mr. Childers to drive him back towards his residence so that he could retrieve an item.
And what items did he want to retrieve?
Mr. Childers tells us that Mr. Valerio wanted to go by way of the wash behind Naples Boulevard, come through the wash, in other words, not go directly to the residence, but walk through the wash and come up behind the building so that he could get into his apartment to retrieve a handgun from a washing machine where he had hidden it.
Now you have Mr. Valerio in your custody at this point. What do you do with Mr. Valerio?
At that point, Mr. Valerio is taken into custody. The lead detectives in the case are, as I said, Bob Leonard and Detective Dillard. And they wanted him transported back to our homicide office, where we have small interview rooms that we take a suspect into, and he was detained there with me. I sat with him awaiting those detectives to come to the detective bureau to do that interview.
Eventually, does there come a point in time when Dave Hatch arrives in the area where Mr. Valerio is being held?
Yes.
And describe for Liz and the jury what happens at that point.
Well, at some point after his responsibilities at the shooting scene, Detective Hatch leaves the Naples Street, returns to the detective bureau. He is aware that I am sitting with Mr. Valerio, and Detective Hatch comes to the interview room where I am, and these have sliding doors, which I have the door ajar for fresh air to come in, and Detective Hatch reached his head in the door at that point, and I recognized him. And he looked at Mr. Valerio, and he used his hand and made a picture, or not a picture, but a motion with his hand like he had a gun and pointed it at John Valerio. That was what Detective Hatch did.
And what was the response from Mr. Valerio to that?
Mr. Valerio, who had been really calm with me up until that point, got upset and said, I should have hit you, I tried to. And referring to the automobile and what he was doing with the vehicle on Naples.
And that caused an argument then to ensue between Detective Hatch and Mr. Valerio?
It went back and forth for a couple of words, but Detective Hatch retreated from the doorway, and then Mr. Valerio calmed down.
Eventually, were you asked to transport Mr. Valerio to the Clark County Detention Center?
Yes.
And when you took Mr. Valerio to the Clark County...
Welcome back to the Law News Network. I'm your host, Caroline Polisi, and we're catching you up to speed this afternoon and morning on the John Valerio trial. We're going to go live in that courtroom at 4 p.m., but until then, we're replaying some clips of previous testimony in the days prior. I'm joined here with Deborah Blum. Thanks for coming, Deborah, as always. And I want to get into this trial a little bit. I want to pick it apart because one of the really main issue here is whether or not there are aggravating factors. And we've talked a little bit about what that means. Now, the potentials for aggravating factors here are threat of violence, torture, mutilation, random crime, or non-consensual sexual penetration. So I think, any number of those could come into play here, which is why I'm going to switch to seeing some testimony of medical examiners here. The next clip we're going to show is of a medical examiner, but I want to ask a little bit about how medical examiners in general, and in this case in particular, play to juries, and just what their role is in the trial.
Well, I'm surprised that the medical examiner is still able to testify.
She's not. Good point. She's not. We're reading back testimony from 31 years ago, so she's not.
I guess that they got an exception here, right, because typically you wouldn't be allowed to do that. But, this case is very unique. So there is a very important function for the medical examiner to serve. They have to identify the cause of death. They have to meet that element of the crime for the prosecution and the defense. If this was not a death penalty case, if this was a case of the actual murder, would try to pick apart their testimony and say, no, that's not the cause of death, or, many other things to try to exonerate their client. But in this case, the medical examiner would have testified to how many stab wounds she observed, how bad the body was mutilated. So it's going to come into play a lot in this matter.
Yeah, I think this is really going to be key testimony, specifically in this trial, when we're just focused on aggravating circumstances, because here we really only have the medical examiner to go on any type of scientific analysis of what occurred pre and post death, because as horrible and gory as it sounds, when you talk about torture, the question is how many of these wounds were inflicted prior to death versus after death. So, and then you get into a discussion of mutilation of a corpse. So the medical examiner, I think, is someone that a jury really puts a lot of trust into. Do you ever, in cases, put on, if you do choose to put on a defense case, do you ever put on a medical examiner to rebut testimony of the state's medical examiners?
I haven't done so, but I absolutely would if I felt it was appropriate. You need to do whatever it takes to protect your client. And in this case, it's very hard for the jury because they're not actually hearing it from this woman's mouth. They're hearing it from trial testimony 30 years ago. Times were different. Techniques were different, so it's possible that the science wasn't as good as it is now, so that's maybe something the defense here can raise. But unfortunately it does, as you said, it's whether or not the person died, how quickly after they were stabbed initially did they die, were they then mutilating a corpse?
Right.
So
And you raise a really interesting point that comes into play when we talk about trying a case 31 years after it happened and 29 years after the trial took place, which is a defendant's right to confront witnesses, right? We have a constitutional right to do that. And the fact that this medical examiner, who I think is going to have some of the most key testimony here, the fact that she is no longer available to be cross-examined, I think raises some pretty serious constitutional questions here for this defendant. Do you agree?
Absolutely. That's a very, very interesting point. If he gets sentenced to death again, it's possible he's going to file the same type of appeal and also a writ to stop the death penalty, because a defendant has a constitutional right to cross-examine the witnesses against them, and that's a Sixth Amendment right. There have been a few Supreme Court cases that scale that back, and then the states each interpret it in their own ways, but it is a fundamental right.
Right. I think we're both on the same page here. I see another potential appeal here should it not go the way that this defendant would like it to go. So I want to take you guys now to JV 16. This is Lisa Luziak. She's reading prior testimony, as we stated, of Nina Hollander, who was medical examiner in this first trial.
Yes. Let's start with the wounds which were not knife wounds, which you found on the top of the head. Could you describe those for us, please?
She had a blunt trauma lacerations, that is tears in the skin on the left side of the head.
Would you point to your own head before we start? I'm sorry. I had asked you before to provide me with a diagram. Do you have that with you now? You have given me two diagrams. Thank you. Let me give one to Ms. Frazier, and I would like the other one marked next in order. Clerk said 69. The court, are they duplicates, or is one the front and one the back?
No, those are duplicates.
Showing you now what has been marked as proposed exhibit number 69. Can you tell us what this represents?
This represents a diagram front and back of the individual that I did the autopsy on, and the injuries are marked on the diagram.
All right. All of the injuries that you located on the body through your internal and external examination.
Yes.
And the copy that Ms. Frazier has, is that the same thing as what has been marked here as 69?
Yes.
Do those marks that you have placed on the front and back portions of those body pictures accurately depict the wounds as you saw them on the body of the individual depicted in State's Exhibit number 5?
Yes, more or less at the location of the wounds, yes.
Will using this particular diagram in conjunction with certain photographs assist you in better describing the injuries to the jury?
Yes.
I would move for its admission, Judge, that is 69. Can you come in State's Exhibit number 69? Do you have a pen, Doctor?
Yes.
If it's easier, I would provide you with one. What I would like to do is to go through the photographs which I am presenting, holding, and well, let's do this first of all. I want to show you State's proposed exhibits. The court, State's Exhibit 69 will be withdrawn from evidence at this time. I'm going to show you State's Exhibits 7, 9, 10, 11, 12, 13, 14, 15, 17, 18, 19. I would ask that you would look at all of those and tell me if those photographs depict various portions of the body shown in State's proposed exhibit number 5, which was the subject of the autopsy that day.
They do, except for number 15. I can't orient myself as to number 15.
Was there any place on the body of the person upon whom you did the autopsy where there was a single knife wound?
The back.
Okay. Do you see more than one knife wound on the exhibit which you're questioning, which for the record is 15?
No, I just see the one.
Would that be the knife wound to the back?
I can't orient myself with the rest of the portions shown.
The other pictures which I have shown to you, with the exception of 15, they all appear to be familiar to you as showing portions of the body depicted in number 5.
Yes.
Are all of those photographs which I have shown to you fair and accurate representations of the scene of the body at the time you were doing the autopsy?
Yes.
Were you in when those photographs were actually taken?
Yes, I was.
They were taken by Officer Roderick, weren't they?
Yes, they were.
I would move for the admission, Judge. The court, what has been marked as States Exhibits 7, 9, 10, 11, 12, 13, 14, 17, 18, and 19 may be received in evidence as States Exhibits and as law. Thank you, Judge. Now I want to refer you back to State's Proposed Exhibit 69, which is a diagram which you have drawn showing the front and back portions of the human form. Was it your testimony before that the wounds depicted in the photographs that have just been emitted are also reflected on the diagram number 69?
Yes.
What I would like to do, if it's possible, Doctor, is to go through the photographs one at a time, beginning with Exhibit 7, and I'd like you to tell the jury what the exhibit is, and then mark the number 7 on the diagram wherever is appropriate.
Number 7 shows stab wounds of the top of the head on the right side.
Would you mark a number by the appropriate place on the...
Welcome back to Law News, everyone. We're catching you up on the John Valerio trial. We're going to go live in that courtroom at 4 p.m. Right now, we're listening to some of the prior testimony of the medical examiner in the first trial. It's a readback, however, because that medical examiner is no longer available 31 years later. I want to take you now to the next clip of the same medical examiner. She's going to testify about how some of the wounds on the victim's body indicate that there was perhaps a defensive maneuver in this case. So let's go to JV 17 now.
The term defensive wounds.
Yes.
Does that term apply to either of those?
Yes, the term can apply to both the hand and the arm wound.
Could you describe what you mean to the jury?
The defensive wounds are wounds which are sustained in an attempt to ward off a knife or other instrument by the person being stabbed, and it usually is located on the arms or hands.
Could you tell me what your internal examination disclosed that's of major importance in this particular case with reference to any of these knife wounds?
Yes, the knife wounds in the front of the neck penetrated into the muscles of the neck, and one penetrated to between the 3rd and the 4th cervical vertebra, going in between the two and reaching the spinal cord, causing a hemorrhage. The stab wounds of the chest on both sides penetrated into the lungs. There was also one stab wound in the back, which penetrated into the lung from the back. The stab wound of the upper abdomen penetrated into the liver. Those were the major internal injuries. The other stab wounds penetrated into muscles, which caused hemorrhage, but did not penetrate into any vital organs. For instance, all the stab wounds on the back of the neck and the top of the head only penetrated the skin, did not go into the head.
The information about the wounds, both external and internal, that you have given to us, was that information sufficient for you to render an opinion as to the cause of death of this individual?
Yes.
And what was the cause of, please? Cause of death, please.
The cause of death was multiple stab wounds of the neck, the chest, the back.
Could any of those alone, or did all of them together cause the death?
All of them together caused the death.
Was the cause of death homicidal in nature, in your opinion?
Yes.
Would you exclude accident
Yes.
or self-infliction?
Yes, I would.
Were you able at all to make a determination as to the order of the wounds, in which order they were received by the individual?
No, these were numbered for the purpose of convenience, and the numbering which we used in our report does not reflect what order they were received in. It's really not possible to tell what order these wounds were inflicted.
Can you tell us what the effect would have been upon the individual receiving these wounds at the time they were received, insofar as allowing her to continue to move around? Were there any of them, for example, which were completely incapacitating?
There was one wound which would be incapacitating, and that is the one that reached the spinal cord. The wounds to the chest penetrating the lungs would certainly have not been immediately fatal, but they would have certainly been incapacitating.
When you say incapacitating, does that mean that the person receiving it would not be able to be up on her feet and moving about?
She might move about, but not very purposefully.
More in a thrashing, reactionary manner?
Yes.
What kind of force would it take to thrust the knife into the body in the manner in which it was done here?
The stab wounds were through soft tissue, skin and soft tissue. They were not through bone, so the force would be moderate, but not excessive.
Were any body fluids retained so as to allow toxicology exams?
Yes, there was decomposing fluid in the right chest, which was sent for toxicology.
And do you have the results of the toxicology exam?
Yes.
How are toxicology exams done?
Blood or body fluid is obtained by me at the autopsy and sent to a laboratory for toxicological test examination.
And is that a laboratory with whom you work on a regular basis?
Yes, it is. It's the only laboratory we work with, and they send a report on the results.
And do you send body fluids whenever possible from your autopsies to the toxicological department so that they can perform their exams?
Whenever it's necessary, yes.
And it was necessary in this particular case?
Yes.
And do you always receive results back from them?
Yes.
Do you know of any instances in which those results were not correct?
I think there were one or two in which case we called because the results were not reasonable and it was a misprint.
Just a misprint
Yes,
on the piece of paper?
yes.
And that's over the, I can't remember what you said, 2,000 or 3,000 autopsies that you had to do with it?
Well, this is here in Clark County.
How many autopsies would that include?
They do all the work for this medical examiner department, which would include possibly over 1,000 cases a year.
And there have only been a couple of misprints over that period of time?
That I know of, yes.
And just in 1 year, not to mention all the other years that it goes on. Are these reports upon which you rely in order to do your pathology work?
Yes, we rely on them sometimes to make a diagnosis.
What was the level of blood alcohol which was found in the blood of the person depicted in State's Exhibit 5 as a result of the toxicological examination?
The level of alcohol was 0.09 grams %, and this was in the decomposed fluid in the chest.
Does the decomposition have anything to do with the level of blood alcohol?
Yes, it can.
To what extent?
It can increase because of the bacterial decomposition. It can increase a blood alcohol level.
Do you know by what percentage?
No, it varies.
Have you been schooled in that area?
Yes, I have testified many times on that area.
You heard the judge's concern, hypothetically, if this body had been in its decomposed state for 10 days. Well, now let me ask that question and then we'll get back to this one. Do you have an opinion as to how long this body had been decomposing? When it had died prior to the 30th when you did your autopsy?
I was given the information that she was last seen on the 19th of the month, and the amount of decomposition of the body is consistent with that length of time.
So is that a 10-day period that you're talking about?
10 days.
She was found on the 29th.
Yes.
So now back to my question.
Excuse me, she was found on the 30th.
Just after midnight on the 30th.
She was pronounced dead on September 30 at 2:30 a.m.
Okay. Given the fact that the body had been decomposing for 10 days and had been dead for that period of time, would that have any impact at all upon the level of blood alcohol that she had in her system at the time of her death?
Yes. Let me just say that the level of alcohol doesn't change after death, except for changes in decompositional changes. In my experience, the level of alcohol can increase by 0.02. It's 0.02 and she had 0.09. So it is possible that she had a lesser amount of alcohol.
If my mathematics are correct, then she would have been at a 0.07 to a 0.09 at the time of her death.
This is in my experience. Depending on the amount of decomposition or depending on whom you read, the values can differ.
Could she have been at a level higher than 0.09 at the time of her death?
No.
But a level lower, not to be lower than 0.07, is that a fair statement?
She could have been lower, yes.
Then a 0.09?
Lower than a 0.09 and possibly even lower than a 0.07.
Now, is it within the realm of your education experience and schooling that you are able to tell us anything about how many drinks the size of the person depicted in the State's Exhibit 5 would ingest to get her to a level of 0.07 to 0.09?
Yes, there's a formula which will give us the number of drinks.
Okay. Could you utilize that formula and tell us, first of all, let's take 0.09. Can you tell us a number of drinks that this person would have ingested in order to raise her blood alcohol to a 0.09?
The weight of this person was 125 pounds. For a 125-pound person to have a level of 0.09, she would have had to ingest 3 to 4 drinks of alcohol in the hour prior to her death.
Now, would that change at all for the 0.07 number?
That would be less. It would be 2 to 3, but also the weight of 125 is with decompositional changes. It is possible that she weighed somewhat more before she decomposed.
Are we in the ballpark if we say that she had ingested 2 to 4 drinks in the hour prior to her death?
Yes.
Now, referring you back to the toxicological report, does that report do a drug screen to determine whether or not a person has any drugs in their system?
Yes, it does.
And what was the result of that particular part of the toxicological report?
There were no other.
Welcome back to Law News Network. I'm your host, Caroline Polisi, and I'm joined here today with Deborah Blum, LawNewz trial analyst, to talk a little bit about this John Valerio trial. We're catching everybody up on the day before we go live to the courtroom at 4 p.m. We just heard some pretty technical analysis that the first trial had on of the medical examiner. We're hearing a readback, which is why for some of our viewers, if it seems a little bit stilted, it is in fact a readback of the initial testimony because that medical examiner is no longer available 31 years later. So, Deborah, I want to talk a little bit about why do you think they're so intrigued about the exact blood alcohol level of the victim?
Well, I wasn't able to listen carefully there, but it could be many different things. You know, it's a question of whether the defendant forced her to drink and that's why she was intoxicated. I don't think that the defense would take the route of arguing, oh, she was intoxicated, she was involved in some illicit act herself with this man and that led to her death. I can't imagine them trying to do that. That would be a pretty low thing to do, but perhaps it has something to do with her body's ability to respond or process certain things, so it's probably a medical issue.
Interesting, yeah, and we heard about sort of the stab wounds there. There was some questioning about how much blunt force would be necessary to inflict those wounds. I think really they're getting to whether or not this was torture beyond the aggravation, beyond actually just the amount of force that would be necessary to kill this woman, unfortunately. I want to switch gears a little bit and talk about, so this is one case, the first, I believe, in which the Las Vegas, Nevada Supreme Court has said you have to go back and do the sentencing phase here. And the reason was because the Ninth Circuit ruled that this instruction given to the jury about depravity of mind was too vague. And you raise a really interesting point off camera, which is how is this going to affect however many other death row cases are now there that received this instruction? What do you think?
Well, I know that when New York State stopped utilizing the death penalty, those people that were on death row just received a life sentence. So this could possibly have been rectified by, in the interim,